Chris Bebel here again. I'm a former federal prosecutor and I'm a former SEC attorney. Today I'm in private practice and I represent investors who have been defrauded. Indeed, I've represented investors situated throughout the country, and I've also given securities law lectures throughout the country, and I'm a published author in the securities fraud area. So what are we going to talk about today? Well, today we're going to talk about the fact that state and federal investor protection rules and regulations are designed so as to protect the interests of investors. And we're also going to talk about the fact that brokerage firms, sometimes called broker-dealers, must design and implement a system of supervision so as to ensure that the rules are not being broken and that customer interests are being protected. Now, to understand these concepts, let's put things in context. Let's look at some background information. More than 40 years ago, over 4 decades ago, the U.S. Supreme Court issued a decision in United States versus Tefteller. And in that case, the Supreme Court recognized that it is absolutely essential to national prosperity that investors feel confident that they will be treated fairly in the capital markets. And without such a sense of confidence, investors will not be inclined to dedicate their capital towards young, thriving, promising companies. And as a result, those young, thriving companies will be deprived of the assets they need to expand their payroll, to build new plants, to buy new equipment, and so on. So let's look at this from the perspective of a broker-dealer and the supervisory system a broker-dealer must maintain. To understand this, we have to look at the fact that regulators, state and federal, do not have the resources to police all the activities of all the brokerage firms on a detailed, in-depth basis. So regulators leverage their resources by forcing brokerage firms to diligently, intensely supervise the activities of their registered representatives, of their stockbrokers, in other words. And as part of that mandate, broker-dealers are obligated to dedicate sufficient resources so as to provide for effective staffing. They have to maintain a system of follow-up and review so as to ensure that branch managers are in fact fulfilling their supervisory obligations. And they have to respond diligently to red flags, what are commonly referred to as indications of wrongdoing. The problem is there are scores of firms that just don't provide enough money, enough resources, so as to provide for effective supervision, staffing, oversight. And there are firms that really do not fairly, adequately, properly discharge their obligation to engage in follow-up and review, and thereby make sure that the branch managers are fulfilling their obligations. And it's also apparent that there are a number of brokerage firms that are not in a position to vigorously respond to red flags because their supervisory system is so weak that they don't even detect red flags. They don't even detect indications of wrongdoing. So from a bottom line perspective, you may wish to keep these principles in mind. In other words, you may find that it's in your interest to shy away from obscure, skeletal, thinly staffed brokerage firms. Why? Because they may not be in a position to detect wrongdoing by their brokers. They may not be in a position to detect red flags and respond effectively. So, in a nutshell, keep these principles in mind, keep your guard up, and be hesitant to entrust your nest egg to a thinly staffed, skeletal brokerage firms. Now, stay with us. Look for future releases relating to the importance of these key investor protection principles. Thank you.